We started off in the early 90s and we were talking about environmental pollution, environmental issues. And at that time, we were talking about environmental justice. And the issue was revolving around a polluter that was within our jurisdiction and what kind of penalties we could impose and how could we stop that polluter from polluting the environment. But things went beyond that. And later on, we discovered that the polluter was somewhere else and wasn't in the country anymore. So the effects of climate change reached Pakistan, and we realized that while we're not contributing to climate change, we are suffering at the hands of it.
The courts are often confronted with lopsided evidence, in which the evidence presented by private parties tends to be more articulate and having correctly engaged with the issues concerned.
Firstly, it is the challenge of finding the right balance between respect for democratic political processes on the one hand and the protection for nature and future generations on the other hand. Secondly, to find the right balance between the need to act strongly now to fight climate change on the one hand, and on the other hand, the consequences for these people that are affected by these decisions here and now.
I think the big challenge is actually to give teeth to our orders. It's one thing to hold a government to account and to make an order holding it in default. It's another to make sure that it remedies those deficiencies and to police those changes.
Judges must decide cases according to the laws of their jurisdiction, without fear or favour, affection or ill will. Climate change cases are no different. In performing their duty, judges can have no agenda to ensure effective climate action is taken by government or businesses. This does not mean, however, that judges cannot decide cases to ensure effective climate action if to do so is in accordance with the law.
Are South African courts then ready, and will they be able to adapt to the challenges that are posed by climate change impact? I do think that we are ready. Firstly, we do have the necessary legal framework. The right to an environment that is not harmful is enshrined in our Constitution.
The Laghari case, where a farmer had come to the court and said that climate change is affecting the heat that's around us now, is going to lead to drought, and I'll be totally out of my lands and I won't be able to till my lands and do agriculture. So we came up with the constitution of a commission, and commission had all the stakeholders. It had the government, it had international NGOs, it had experts, and it had the petitioner. And we said, why don't you all sit down and evolve a solution to this problem?
With a final decision by the Supreme Court of Ireland in July 2020, Grand Descent with a final decision of the Supreme Administrative Court of France in July 2021, Notre Affaire à tous with a final judgment of the Administrative Tribunal of Paris of last month, Neubauer et Allies with a judgment of the Constitutional Court of Germany in April 2021, the Klimaatzaak, the judgment of the Court of First Instance in Brussels in June 2021, and a first important case on the overall performance of an oil multinational with Milieudefensie and Allies versus Royal Dutch Shell, a judgment of the District Court of The Hague in May 2021. Looking at this jurisprudence, we can discover some common general principles. The protection of life and health includes the protection against environmental pollution. Human rights constitute a positive obligation to protect against environmental harm, including the harm resulting from climate change.
South African courts have a strong culture of having regard to international jurisprudence. And therefore, where our jurisprudence is lagging in climate change jurisprudence, we will readily draw from other jurisdictions.
Climate consciousness refers to an awareness of the climate crisis, its causes and consequences, and the intersections between climate and legal issues. Climate consciousness can inform a court's choices in finding, interpreting, and applying the law.
There are some new principles that necessarily will evolve within the context of climate change itself. But there are environmental law principles, some of them adopted more recently by courts, that will, in my view, play an important role in climate change litigation. Let me mention one, namely the principle of the ecological function of property rights. We tend to believe that climate change litigation is mainly against governments. But it's not just against governments, it's against corporations, it is against private citizens. So it's important that we incorporate that vision that property rights, the bundle of rights, includes at its core an ecological function, a duty to protect the environment.
The court also acted as a place which was creating awareness. The civil society understood what was really happening. So we became kind of a centerpiece which were disseminating information, people were understanding what was happening, the government was understanding what to do, and they were learning from all this.
For example, the right to health, which is also a fundamental right enshrined in our Constitution, which has been interpreted very extensively within the context of the HIV pandemic, is jurisprudence that we can draw from in our interpretation of climate change disputes before us.
I am very optimistic that the courts will be able to adapt to meet the challenges as they come. In this country, the common law has over the centuries proved itself remarkably resilient and flexible to meet changes, not least those of the Industrial Revolution in the 19th century. And the same will happen in the future.
We judges have to be optimistic because we believe in the rule of law, and more recently, we believe in the environmental rule of law. Courts have been very important in changing major aspects of human life in the past 100 years. And I suspect that it will be the same with climate change.
And there are new judges coming up who are following this, and judiciary is making a tremendous impact in Pakistan as far as climate change is concerned.
Disruptions are never easy, and it will not be easy for the courts either. But I have faith in the ability of courts to strike the right balance and to uphold the trust that is needed in societies. We shall manage to fight climate change and give our children the future that they deserve.